Federal High Court sitting in Lagos State has sentenced a businessman, Aniogor Godswill Obiajulu, to 5 years imprisonment for refusing to accept Naira currency as a legal tender in exchange for the sales of Diamond Bracelet, demanding the company customers to pay in dollars, and the court in its ruling on Thursday, ordered the Diamond Bracelet worth over $10,000 to be forfeited to the federal government. This, on the same vein, another federal high court in Ikoyi had on Tuesday sentenced a diamond businessman, Uzondu Precious Chimaobi, to 4 years imprisonment for also refusing to accept Naira as means of payment from his customers, and the court in Ikoyi also ordered the Cartier Diamond Wristwatch worth over $5,700 to be forfeited to the federal government. Details of the news reports as presented by the Public Relations Unit of the Economic and Financial Crimes Commission, EFCC, reads verbatim below. Lagos court jails businessman, company for refusal to accept Naira as legal tender. Justice Akintayo Aluko of the Federal High Court sitting in Ikoyi, Lagos, on Thursday, April 17, 2025 convicted and sentenced a businessman, Aniogor Godswill Obiajulu, and his company, ICW, to 5 years imprisonment for their refusal to accept the Naira as a legal tender. Obiajulu, alongside ICW, was arraigned on Thursday on a 2-count charge bordering on refusal to accept the Naira as a legal tender. Count 1 reads, that ICW and Aniogor Godswill Obiajulu, on the 10th day of December, 2024 in Lagos, within the jurisdiction of this honorable court, refused to accept Naira, Nigeria's legal tender, by accepting the sum of $10,000, $10,000 as a means of payment for the purchase of 1 diamond clover bracelet, and you thereby committed an offense contrary to and punishable under Section 21 of the Central Bank of Nigeria Act, 2007. Count 2 reads, that ICW and Aniogor Godswill Obiajulu, on the 10th day of December, 2024 in Lagos, within the jurisdiction of this honorable court, directly retained the total sum of $10,000, $10,000, which sum you reasonably ought to have known forms part of the proceeds of your unlawful activity, to wit, pricing and accepting USD as a means of payment for goods and services, and you thereby committed an offense contrary to Section 18(2)(d) of the Money Laundering, Prevention and Prohibition Act, 2022, and punishable under Section 18(3) of the same act. He pleaded guilty to the charges when they were read to him. In view of his plea, prosecution counsel, C.C.